Alrighty. So good evening, everyone. Thank you so much for joining us tonight for our prospective student event. My name is Carly Gardner. I'm the Assistant Dean of Admissions here at Delaware Law School. I'm also a proud Delaware alum and practicing attorney, so I'm really thrilled that you're considering law school, and specifically that you're considering Delaware Law School. In addition to tonight's event, I just want to plug for another event we have upcoming. We're hosting a daytime event on campus on Saturday, January 25th, to help you learn more about Delaware law, our programs, our faculty, our students. So that on-campus event will feature presentations on the Delaware law programs and opportunities that I just kind of alluded to. It'll feature a presentation on the application process, how to write an effective personal statement. It will also feature a mock class, another mock class, this time taught by the dean of the law school. We're also going to have current students at that event so that you have an opportunity to connect with them and take campus tours. So you can register for that event the same way that you registered for this event on our website. And I hope that you will join us. You'll have such a great time tonight that you'll want to join us in person on Saturday.
No pressure on
Um,
me.
no pressure, Professor Colleen. While our signature programs and our practical skills opportunities to me are really important parts of our identity as a law school, I think that, tonight we really want to focus on perhaps my favorite part of the Delaware Law School, which is our faculty and our students. We're going to start tonight's program with a mock class taught by one of our wonderful professors here, Professor John Colhane, followed by perspectives from some of our current students, and then followed by Q&A. And again, this is a really great intimate setting where you can get all those questions answered. So we hope we can do that for you tonight. Well, tonight's event is intended for students interested in both our full-time and our part-time programs. We are hoping that tonight we get to highlight our part-time program just a little bit in a few ways, and I'll tell you what those are. So first is the timing and the virtual format of this event. So our part-time students are going to school at night. I think their first class would be starting now at 6. So it gives you kind of an understanding of that, timing for a first-year law school class. But also for the format, for the 2025-2026 academic year, Delaware Law is going to be piloting a program where our first year part-time evening students are going to benefit from a hybrid approach to learning that includes both in-person and remote classroom instruction. Happy to answer more questions about that toward the end. Our full-time program is going to remain completely in person. But I did want to give you that distinction for next year that may be valuable as you're considering Delaware Law School. And so the second way we're highlighting our evening division students, again, just a touch, is that our current students who are joining us tonight are from our part-time program. Just because they're in the part-time program doesn't mean that their perspective and their advice is not going to translate to you as a prospective full-time student. So I hope that their willingness to share is helpful to you no matter what path you are considering. So with all of that as background, I want to stop talking. I want to turn the floor over so we can get our mock class started, because that is why you're all here, to get a glimpse of what law school is all about. So I want to thank Professor John Colhane, who is joining us tonight to lead that mock class. Professor Colhane teaches in the areas of torts, family law, constitutional law, and public health law. He's also our Associate Dean for Faculty Development and our co-director of our Family Health Law and Policy Institute. His scholarship covers a wide area, including issues in tort law, family law, First Amendment, public health law, and LGBTQ plus legal issues. He's published several books and articles, and he regularly appears in media as a legal expert. He has won the Outstanding Faculty Member Award, I think, 3 times so far, which is just incredible. Our students are, big fans. And I think most importantly, Professor Colhane is a collaborative and inclusive leader here on our campus who's committed to the success of our students, both in the classroom through his instruction, but also beyond and outside the classroom and through their careers. So really grateful to Professor Colhane for being with us here tonight, and to offer you all a glimpse into what a law school class looks like. So without further ado, I will turn it over to you, Professor Colhane.
Thanks. It's a lot to live up to, so I'll see if I can do this. So, one of my great pleasures as a law professor for many years has been to teach first year courses, especially first semester first year courses. And my first semester course, as Carly pointed out, is tort law. And so, in case you don't know what tort law is, we're talking really about civil liability, right? About negligence and intentional torts and things like defamation and privacy, any private right of any private action that one person might bring against another for injury, basically. It's anything from a car accident to medical malpractice, product liability, or things that we see in the news all the time these days, defamation, privacy violations, especially in the era of artificial intelligence, where it's much easier to, to show a fake of somebody and intrude on their privacy that way. So we cover all of that in a first year torts class. And I think it would always be my favorite course to teach because the stories in torts are so relatable. And so when I was thinking about what I wanted to do for this mock class, I thought I would take something that was interesting, right? And at a level where people who haven't had any law school experience could sort of feel as though they had some connection to the material right away. Okay. So this will be a combination of this will be a little bit like a law school class in the sense that um, it's very participatory, it's very interactive. Okay. And so maybe your undergraduate experience was similar, and maybe it wasn't, but in law school, there's a big emphasis on students and talking to each other, talking to faculty, and trying to work through the cases and the arguments as best we can. So, what I've chosen to do for tonight is to take the simplest, most basic tort, which is battery. It's an intentional tort. I'm going to talk a little bit about what a battery is, but then we're going to focus on what it means to consent to contact. Okay. So most of what I'm going to be focusing on tonight and what we're going to be discussing is how consent is expressed, what the scope is of consent, and just to get a sense of some of the complexities that the law involves. All right. So let me begin. I'm going to move you all over to my other screen. Right. And so I can still see you. And then I am going to share my screen with you all. This one. And you should be able to, and when I say should, there it is. So can you see my screen? Yes?
Not yet.
Not yet. Let me know when it comes up. It should be there by now. Still no?
I'm not seeing it.
Okay. So this is my final day as a law professor. No, so one of the things you learn to do is to roll with it. I'm going to switch and see if that helps. I'm going to switch screens here. I'm going to exit the slideshow, move this over, move you guys up, share screen. This says one beginning. Okay. So I see the problem. I think, Carla, you may have been sharing screen at the same time. Can you see um, any screen now of any kind?
I cannot.
Okay, so here's what we're going to do. We're going to pretend we see the screen. All right. This is an exercise in creative imagination and dealing with tech. So what I was going to do is show you a screen that basically defines the tort of battery for you. Okay. So in real life, what I would do is you'd have the screen and then I would provide these PowerPoint slides to you. Okay. Sometimes they'll be provided before class. If there's preparation I want you to do, sometimes we'll go over them in class. This is again talking about the remote option, which as evening students you would have once a week. And then Sometimes I would provide the screens after class if I had a particular or the slides after class if I had a particular reason to do that. So how do we define? So a battery is the most basic intentional tort, right? The idea is you make contact with somebody that you shouldn't have. I mean, it's that simple, really. All right. So a battery says, or the definition of battery is that a person is liable to another person for battery if the first person acts intending to cause a harmful contact with the other person and a harmful contact results. I mean, it's that simple. It couldn't be any simpler. So just, you punch somebody, that's a battery. It's also a crime, right? You can be criminally prosecuted, but a harmful battery is you cause personal injury to somebody through your intentional conduct and making contact with them. It's the first tort we cover, right, in law school, the tort of battery. So then the question becomes, well, not all punches are the same, right? So what would be an obvious example of two people punching each other where they couldn't sue each other? Just think for a second. What would be a good example of that in real life? Anybody want to volunteer? Tania or Tanaya? Sorry.
It's Tiana.
Yeah, sorry. I had
No
to write the
worries.
first one right.
No worries. If they were maybe boxing,
Yeah, if they're in a boxing match, it's the most obvious example, right? So they're in a sanctioned boxing match, they can't then sue each other for battery, right? And why is that? Think about it, think about it sort of from a practical perspective. What for what reason are they not able to sue each other?
Professor, would it be because that is the intention of the activity? That
Yeah,
is the whole purpose of going into that
yeah.
activity, knowing the outcome.
Or knowing that, well, the outcome is you're going to be hit. You don't know whether you're going to win or lose, but for sure you're going to be hit, right? And if you're not expecting to be hit, don't go into the boxing ring. Right? Pro tip, right? So if you're boxing, what you've consented to being hit, right? So one of the most important defenses to a battery claim, just like criminal law has defenses, so does tort law, right? So we have this defense of consent. Okay. So if you consent to being hit, right, then you can't sue the person for battery. And a boxing match would be an obvious example of that. Okay. So here we go. I'm just trying to go to my next slide. So as you can imagine, there are different issues that arise when we're talking about consent. And I want to talk about three things that courts and state legislatures have focused on, right? So the first one is who has the capacity to consent? And what I mean by that is not everybody's in a position where they can validly legally consent, right? So that's the first question. The second question is how was that consent expressed, right? How do you express the consent? It's verbal, it can be nonverbal. How is that consent expressed so as to be effective, right? And then the third question, and the one we're going to spend the most time on, because it's by far the most interesting, is what is the scope of that consent, right? So if two people are boxing, they've consented to injure each other with their fists, but I'm guessing they haven't consented to pull out pistols and shoot each other, right? That would be beyond the scope of the consent, just to give a real obvious example, okay? So when we go through all the intentional torts in a first year torts class, and then we come back around and talk about the defenses to those intentional torts. And the one that gets the most attention and the one that's the most significant is consent. Okay. So let's talk first of all about who has the capacity to consent and who doesn't. Well, we're all adults in this room, right? Presumably, we can consent to being, slapped on the back by a friend, for example, right? We might do that by telling them they can do it, but more likely through our relationship and our course of conduct, right? So as adults, we generally think we have the capacity to consent, right? So who under what circumstances might you imagine a person would not have the capacity to consent?
when my husband was ill with brain cancer with glioblastoma. He was in recovery and they had to go back in the next day and put a stent in. He was not able, I had to provide that consent. He was
That's
incapacitated. He could not consent to that. He was still somewhat coming out of the first surgery, and
right.
Penn had to go back in because it was not draining. The blood and the swelling and the fluid was not draining.
Yeah.
I had to provide the consent for that.
Yeah. Well, first of all, let me just say how sorry I am to hear about that. I mean, I'm sure
Thank you.
it's it's a tremendously difficult and emotional, journey to be on. And you're absolutely right. When a person is unconscious and they're under anesthesia, at that time, they do not have the capacity to consent. And what they do, and this is going to turn out to be really a good example for one of the cases I want to talk about, is you get someone to consent for you, right? You appoint someone to be in your stead as a person who can consent, right? And so it would usually be, if there is a spouse, it would typically be the spouse, or it could be some other person who's next to kin, or it could just be a friend if you designate that person to consent for you, right? Children generally don't have the capacity to consent. It's a little more complicated as they get older. In certain contexts, they can offer consent. People who have guardians, who have legal guardians, who are legally incapable of making decisions for themselves, right? So these are all situations in which either temporarily, as in the case Rebecca was mentioning, or I guess with children it's temporary because one day they'll grow up, right? Or maybe with people under guardianship it's more permanent, but either temporarily or permanently, they don't have the capacity to consent. So that's the first issue. Not usually an issue, but as we'll see, it comes up as an issue in one of the cases we're going to be discussing. Then the second question is, well, how, if we are trying to get consent, how is that consent expressed? Okay. So the easiest thing is, of course, if it's verbally expressed. So in the case Rebecca was mentioning with her husband, you would say verbally, yes, you could go ahead and do this, right? You're standing in his place, right? Giving consent on his behalf, and you're expressing that clearly and verbally. And that's one way that consent can be expressed, and often is. All right. How else might we express consent? Connor, any ideas?
Through a contract.
Yes, that's true. You can express consent formally through a contract, but that's verbal in a way too, right? It's just that it's in writing versus oral, right? But can you think of less formal situations in which you might be consenting to people making contact with you?
Through like mannerisms or actions that indicate consent.
Of course, that's exactly right. So there's a well-known case back in the days when immigrants would come in on ships from Europe, and there was a concern about smallpox, and so people would get vaccinated against smallpox. And so there's a line, and this woman says, "I've already been vaccinated." Doctor says, "Well, there's no mark on your arm, right?" And so she says, "But I was vaccinated." And then she sees people ahead of her online holding out their arms to get vaccinated. She holds out her arm. The doctor vaccinates her. Later, she develops complications from the smallpox vaccine, right? And says that was a harmful contact and I didn't consent to it. And the court says there's evidence that you held out your arm, right, to accept the vaccination. That's consent. I mean, you basically, without saying it, you said it. Okay. Or think about being involved if you're, uh, involved in sports, or let's say you play a pickup game of basketball or something, right? Or football. There's going to be some contact that's involved in that, and you generally don't stand around before the game and say, "I consent to only this much contact." It's sort of understood as part of the game what you're consenting to and not consenting to, and you're expressing it just by participating, right, in the game up to a point. Right? Again, we can get into the scope of that consent, but you're consenting to whatever it would be the usual amount of contact that would be incidental to playing that game. Okay. So uh, I want to spend the rest of the time talking about a difficult issue, which is what is the scope of the consent? And it would be much better if I could pull up the damn screen here because I've got a lot of
Professor
text.
Colhane, if you want to
Yeah.
shoot me your presentation, perhaps I can try to share.
Oh, let's do that. This sounds like a great idea. So I'm
Lots of
going.
teamwork at Delaware Law.
Oh, I know. We were hoping not to demonstrate it so in such a context, but sometimes. All right, there we are. All right, I'm going to attach this presentation. Hang on for a second. Um, let's see. Oh, I see what happened. Hang on. I have to escape from this. All right. I'm going to send it to you now. Heck. You should have it in a minute. I'm trying to, I know what to do. Da, da, da. Sorry, this is being obnoxious to me. There we go. All right, here it comes. Let me know when you have it, all right? Right?
Let me pull it up.
Yep, hold on. Why is it not letting me attach it in this way? Copy. Open with, oh, there we go. I may have to save it to OneDrive. Let me start talking about it. I think let's see if I can walk and chew gum at the same time. All right. So this was a well-known case from about 1905 when what happened was, I see. Okay. So this woman was experiencing hearing loss in both of her ears. And so she went to a specialist. Remember, it's 1905, so the state of medicine was, pretty primitive, right? So, so she goes to the doctor, and the doctor examines her right ear, and what he finds is that it's in a very diseased condition, and he realizes that he's going to have to operate. Right. So he hang on for a second, attachments. I don't know why this isn't happening. So anyway, uh, he says, I'm gonna have to operate on the right ear. That's all there is to it. All right. So then he looks at the left ear. I'm just gonna do this. And he can't examine it thoroughly. Why? Because, as the court put it, there were foreign substances in the left ear. I don't know what that means. Was it wax? I don't know. Was there a thimble in there? I don't know what the foreign substances were, but there's something in there, right? So he can't do a thorough examination of the left ear. And it's when you read the decision by the court, it's impossible to tell exactly why uh, what he did next. Okay, so imagine you're his patient, right? And he says, "I can't examine your left ear right now." What would be the what would how would that conversation unfold from there? Because we can't tell that there was any subsequent conversation as far as the record in the court discloses. So let's see. Michael Rodriguez, do you have some idea? What would you expect would happen there as a practical matter?
I mean, as a practical matter, I would expect that, this person would want to know more about what care is going to be provided or why
Yeah,
provide what we're going to do about that.
it's like, okay, I can't get into your left ear. I'll see you later. We're just going to work on your right ear. Did she get like half price? I mean, it makes no sense to me. You go in for an ear exam, you expect both ears to be examined, right? I've never quite understood this case, right? I always thought it was kind of eerie. Get it? Anyway, so sorry. So this is what my students have to put up with on a daily basis, really bad puns. So what happens next is she goes to visit her family physician that she'd been going to forever, her primary care doctor. And she explains the situation, and he says, "Yeah, I think you probably should get the operation." She wants his opinion. She trusts him, right? So, and she says, "And I want you to be there during the surgery." Okay, so surgery takes place, and the specialist is the one doing the operation, and he looks at the right ear, right? And he says, actually, this ear, when he's able to get in there better with his surgical equipment, says, actually, there's less aggressive treatment I could use for the right ear. So I'm not going to do the surgery I plan to do. But while I'm in the neighborhood, I'm going to look at the left ear, right? And then he looks at the left ear. Now we can get a clearer sense of what's in the left ear, right? Then he decides that the left ear needs surgery. Okay. So he goes ahead and operates on the left ear, right? Well, I think you can guess what happened since this is a torts case. She loses all hearing in the left ear. All right. She can't prove that the doctor was negligent in the way that usually this would be a medical malpractice case, right? Where you would try to prove that the doctor was negligent in the way the surgery was conducted. But there was no evidence of that. Okay. So her argument was really basic. She said, this was a battery, right? This is her argument. I did not consent to have my left ear operated on at all, right? I only consented to an operation. I'm sorry, I didn't consent to my left ear. I only consented to an operation on my right ear. All right. What do you think? Does she have a claim? Did what the doctor did with the surgery, did it exceed the scope of the consent that she provided? Madalena, what do you think? First of all, am I pronouncing your name correctly?
Yes, you did pronounce it correctly, but I go by Maddie.
Oh, okay.
Um, I would say yes, because he previously told her he couldn't even look at her left ear.
So you think she did consent?
No, I think that she
Oh,
did not. She was expecting that only the right was being worked on.
yeah. And do you think doctors should have a privilege to, I'm going to put this in a way where the answer will be obvious, roam about freely within the body looking for other problems?
No.
No. I mean, we value our personal autonomy, right? This is the whole reason we want the consent to be expressed and expressed, right? We don't want the doctor to be able to say after the fact, well, this was the most reasonable thing to do. And in fact, with consent, even if a reasonable person would have consented in that position, right? Which probably they would have, it doesn't matter, right? The fact is that he didn't seek her consent for that, right? Nor did he obtain it. And therefore, the court found that she had not consented. Okay. Let's say go ahead,
Professor,
Rebecca.
can I play devil's advocate?
You
You just
can.
made me think of something, and knowing that this is not at the turn of the century.
Yeah, exactly. Right.
The Princess of Wales in March, it was shared that she had been going through surgery, and during that surgery is when they found the cancer. So I'm thinking of that example what would they have said? Oh, well, we didn't have your consent, so we just took care of the one thing and closed you on up, and good luck to you. We're gonna
Yeah,
shift you off to an oncologist because
yeah,
that was my understanding. So I'm wondering where that falls. Or do they have the right, the ability to say, okay, we were doing this other thing, because I don't think they ever really said what they were operating on, but that was how I understood it.
yeah.
So were they within reason? Did they go in and operate and take care of some of the cancer while they were doing some of this other thing? I have no idea. Maybe because they just on the news,
Yeah.
they were
So it's
saying
a
that,
great,
hey,
right. So it's a great question. And I don't want to, I could answer it with about a 10-minute answer, but I'm going to give you the 2-minute answer, right? Because law professors were not known for being short of speech, right? So I could give you the whole thing, but I'm just going to give you the basics, right? So first thing you're absolutely right to emphasize that this happened in 1905. This case, I can't imagine it happening today because there are consent forms, right? You would have somebody standing by to consent for you, as you did in your case, right? There are lots of other things. And by the way, the doctor argued that her family physician was empowered to consent for her in that case. And that was not, the court didn't accept that argument. So he was just there for reassurance. She never gave him the power of attorney, right, to make that medical decision. So that was an argument that was raised. There is the law gets a little bit tricky. It may be a little bit different in the UK than it is in the US, but basically, if the doctor is operating on a part of the body and something is discovered, right, that needs care, if it's a true emergency, like it has to be done then the doctor has a privilege to do it. All right. If it's not that, well, cancer is urgent, obviously, but if it's not something that has to be done right away, but needs to be done, then courts are split on whether the emergency rule extends that far. Okay. So, and again, in the UK, it could be slightly different. All right. So there's a case where you're not going to accidentally find the a problem in the left ear when you're looking into the right ear. That's just not going to happen unless the person's head is hollow, right? So just because they're both ears doesn't mean you get to go from right to left in that situation. And the court said the biggest problem she has, right? They sent the case back down because the lower court, there was a disagreement between the lower court and the first appellate court about the proper application of the law. They sent the case back down to the trial court, and they said the question really is whether the doctor's incursion into her left ear actually caused the deafness. If it didn't, it's still a battery, but the damages would be much less, right? Then you're just recovering for the unwanted intrusion into your body. Okay. But if she could show that it was really her hearing loss was caused by that surgery, even though it wasn't negligent, right? Then she would have fuller recovery of all of her damages. Okay. And that was something to be decided when the case went back down to the lower court for a retrial. All right. So the last case I want to talk about, and Carly, what I might ask you to do is go to YouTube and go and find the because this really will be important to have the video up. It's you want to look for More, the last name, Bertuzzi, Bertuzzi, and then either hockey or NHL or something like that. And it should pop up almost immediately. Do you see that?
Is it a sucker punch?
Yes. So you've
Okay.
got there are a number of videos there. You're looking for the 8.5 minute one. We're not going to show the whole thing. It should be at the
Right.
top of the
Yep.
list. Go to about the two. I'm glad I thought this out. Go to the 2:30 mark on the video. All right. Then share screen and
Number two.
just play it until about 3 minutes. I'll tell you when to stop. You have to share screen first,
Yep.
right? Show
Yep.
them this video, maybe in full screen if you can.
Sure. Give me 1 second while I find your going to go into 2 minutes 30.
Yeah, go to 2:30. And we
And
only
while
need
I
to see this bit. Don't start it till I say start it. You know.
Okay. And while I get this pulled up, I do want to welcome. We have actually Michael's been a plant. Michael Rodriguez is one of our current students in the room. We were just joined by
Why?
Justice Gettle and Elijah Smarito. So I just want to welcome them. We're doing a mock class, so we're looking forward to speaking to you guys soon. So let me
Is your
pull
first
this
name
up.
Justice, or is it what you stand for, or is it both?
I guess you could say it's both, but
Good.
not the first name.
Okay, you're a good candidate for law school, right? With a name like Justice. Um, Maybe one day you'll be Justice Justice. Okay, so before we start this, I want to sort of give you some context. So this is a hockey game, obviously, right? And what you're about to see is one hockey player, right, sucker punching the other. And I just want you to, and this is, they didn't show this initially, but they did the replay after a commercial. And this is the part that I want you just to watch what happened from about 2:30. And Crowley, I'm going to stop you right around 3 minutes. It's just a very short clip that you need to see. And then we'll talk about it, as they say in the media, on the other side. Can we get sound? Okay, just watch this. See the punch? Drives him into the ice. And then there's this huge pileup. All right. And they'll show it from this angle. Okay, Carly, you can stop there. And this is where they're tending to the guy who was punched. Okay. Um, it's pretty serious, right? Doesn't it? Does it look serious to you? Right. So the question is, this is professional hockey. And as you know, if you pay any attention at all to hockey, even for 1 minute, you know that there's a lot of fighting that happens in hockey. You know the joke? I went to a fight and a hockey game broke out, right? So there's this expectation that there's a lot of contact in hockey, even though it's not officially part of the game, right? So the question is, this guy who was punched, right, sucker punched, he didn't know it was coming, his head driven into the ice, okay, and then this huge pile of humanity, although he might be using that term lightly, loosely, piles up on this guy. He's unconscious, and that's the end of his hockey career, by the way. All right, it's over. The guy who did it was suspended, and a lawsuit was brought by the person who was injured. And the question is, or one of the big question was whether this kind of contact exceeded the scope of the consent. I always start when I do this case and talk about it, I always start by asking whether there's anybody in the class who has any experience playing hockey, because that's really valuable in kind of understanding what's expected and what's not expected. So is there anybody here who played hockey? Okay. Oh, you did? I'm glad you're here. So,
Yeah, when I was younger, though,
all right.
nothing serious.
Okay. Does this seem to you like the kind of thing you can do in hockey? What you just saw?
Uh, I would say not
You would say
really.
yes. You a hockey? Do you watch hockey?
Every so often.
Okay.
Yeah, but
Do you have any hockey
not.
fans here? Yeah. Okay. So Rebecca, what do you know about fighting in hockey, if anything?
It's going to happen and it's not pretty and it can be very brutal.
It can
And
be.
and the Philadelphia fans love it. That's what I can answer.
Yeah. Well, what the students have told me who have played hockey is that there is fighting and it's expected. It's a regular part of the game, but there's actually a protocol to it, which really surprised me the first time I heard it. So the players face each other, right? They take off their gloves and put down their sticks, and they are fighting kind of face to face. So this is not, by the way, this is not in the rules. But it's in the practice, it's in the custom of hockey, right? So if that were to happen and you would be injured more severely than you would expect, you likely would not have a claim, right? Because that's just part of what you expect, at least at the professional level, right? So now that I've told you that, Justice, what's your take on this? Do you think this should be treated the same way?
I would still stick with my answer and say it shouldn't be because it's a punch to the back of the head, and that's not
Yeah, it's a
typical.
punch to the back. It's a sucker punch. It was retaliation. If I had more time, I would show you the whole sort of lead up into it, where there are these enforcers who get back at other players. It's a whole hockey's complicated in this way, right? And so this guy, it was a retaliation for a hit that Steve Moore had done on somebody earlier. But this kind of sucker punch and then driving the guy's head into the ice where he was unconscious and really was lucky to survive, basically. And many years later, he was talking about the case finally settled for what was known to be a large but undisclosed sum, right? And so the question is whether this exceeded the scope of the consent. We don't know for sure because the case settled, but the thinking is it settled for so much money because it was thought that the plaintiff, the guy who was hit, Steve Moore, had a very strong case, that this was beyond, even in hockey, and there are football cases too, right? If the play is over, you don't get to jump on top of the person, right? And there's actually a case like this. So even in sports where depending on the sport, it's different as well, right? But even in a sports context, there's a limitation to what we consider to be the scope of the consent. So if you were to come to the law school and you were in my torts class, somebody one day will seem familiar to you because this is a case that we do, but obviously we kind of expanded out, right, to talk about it in more depth. And of course, you've had a much fuller exposure to the tort of battery, so you have more nuance to kind of bring to it. But you all did a really nice job just in kind of dealing with the limited background that I gave you. And I appreciate your patience with our tech glitches, but I think we got through it okay. In real life, you would see the PowerPoint and you would have it uh, to keep and to have and to hold and to treasure. Uh, and I use an online program for my course, which would have the video. It does have the video posted to the chart that I use for torts, which a lot of students prefer to the standard casebook. And I think in an online setting, it's especially useful to have a casebook that's all electronic. So that's all I have in terms of what I wanted to present to you. And I welcome any, I guess I can do this. Do you have any questions about what we just covered? Carly, up to you.
I'm happy if anybody has questions for Professor Colhane, please don't be shy. I just wanted to echo what Professor Colhane said in that, thank you for your flexibility. We had some tech issues. I do think this is still a good glimpse of what you be grappling with and questions you be working through in class. And I just want to commend you all for your bravery, right? So, as Professor Colhane said, law school is the cold calling is not meant to put anybody on the spot and embarrass anyone. It's really meant to get you to start thinking about these issues and engaging with them, engaging with your classmates, engaging with your professor. So I really appreciate you all participating in that way and want to just congratulate you on that. That's, first step
They consent to
done.
be called on before class? I don't know. I sort of, or there's another tort called intentional infliction of emotional distress. So please don't sue me for that. But I think this is what you'd expect. And I would say the philosophy of the faculty here, particularly in first year classes, but more generally is many of us do cold call on students, but we sort of use a light touch. So we might call on somebody, then we bring somebody else into the conversation or invite other students to share their perspective. And really the idea is to start you on the road to being able to think on your feet, to argue like a lawyer, to understand what are better and worse arguments. And if students are unprepared for class, my personal approach is just let me know before class. that you're unprepared, and I won't call on you that day. And I find that students, rarely take advantage of that. They really want to come to class and to participate because that's how you get the most value for your law school education. And listening to each other is just as important in a lot of ways as listening to the professor. And it can be very different from the model that you may have been accustomed to in undergraduate. Um, so uh, while I never run out of verbiage, I think I'll stop for now.
And absolutely, if anyone does have questions for Professor Colhane and wants to connect, I could certainly facilitate that if you want to reach out to the admissions office. I do want to make sure
Or
if
to
there
me,
are.
or to me directly.
Oh, there
That's
you go.
fine.
Absolutely. See, and I really, I'm, it's so great that you said that because I do think that's reflective of how our faculty are here, really accessible, here for our students. So I appreciate that. And, but if there are no questions, I want to give a chance for our students to speak, because we do have 3 students with us. So I want to thank Professor Colhane so much for being with us here tonight. I'm sure you'll have opportunities to engage with him and our other faculty again. So thank you so much. And we'll move right on to students.
Let me just say my email address, if you want to get in touch with me, is jg Culhane, Culhane, Culhane at widener.edu. So don't be bashful. Just, any questions you have, and that goes for current students as well, but certainly for those of you that are considering your future path as a law student. You know, I've been doing this a long time, and I have a certain perspective, and it can help, like maybe help you with the decision process in some way. I'm happy to do that.
Thanks so much. All right, so I want to pivot a little bit as I kind of mentioned at the top of this program. Tonight was supposed to give you kind of just a little taste of law school, but also give you some student perspectives and give you the opportunity to ask questions directly to them. We're going to have other opportunities. One that I mentioned at the end of this month, for kind of a more in-depth program on the application process. Opportunities to ask admissions professionals questions. But I know what's probably most important to a lot of folks is, what our students think of Delaware law, what their experience has been. So want to turn now to our 3 students that I called out and highlighted. Thank you so much for joining us. I kind of want to just go down the line, have you each introduce yourself, tell us what year you're in, and then I'm really hoping you can share, your Delaware law experience. Maybe how you approach first year classes, I guess in light of what we just saw, how you approach the workload, and really any advice you have for students, and then we can certainly open it up for questions from this group. So I see Michael on my screen first. So Michael, I want to give you an opportunity to take us away for this portion of the program.
Thank you very much, and thank you, Professor. Good evening, everyone. It's nice to see you all. My name is Michael Rodriguez. I'm currently in my 4th year, the extended division or the evening division, depending on how you like it. I'll graduate in May of this year and sit for the Delaware bar in July. I live in Delaware, outside of Dover, so I commute to the law school. I work in Wilmington, where I'll stay on as an associate at a personal injury firm after graduation.
Thank you so much, Michael. Justice is next on my screen.
Sure. My name's Justice Gettle, as you probably can see on your screen. I'm also 4L evening division or extended division, like Michael said. I'm hoping to get a job with the public defender's office in Pennsylvania. So that's just a little bit about me. I will say I'm the vice president of the evening division. So right now I just wanted to let everybody know that we're kind of working on programs and a lot more for our evening division students, just to help everybody out and get everybody involved and advanced in their careers and whatever they want to do.
Thank you. And then I see Elijah next on my screen.
Yep. Hi. I'm Elijah Smarito. I go by Eli. I'm also a 4th year evening division student, along with Justice and Michael. We all know each other pretty well, I'd say. We have pretty much every class together, pretty much up to the last year. But even still, with electives, we still see each other pretty often. I work full time in a very small corporate law firm in Ardmore, Pennsylvania, alongside one other attorney, and I plan to stay there upon graduation. And we specialize in corporate, general corporate governance of startup companies, and also work on some offerings as well, and some M&A transactions too. So really exciting stuff. I really love the experience I've had, and I'll say this as an evening division student, I really was able to take this opportunity to work at this law firm, and it really kind of steered me in the right direction as I progressed through Delaware Law School. So, oh, and also I guess worth mentioning, I'm going to sit for the New Jersey bar and possibly transfer over to Pennsylvania, depending on how well I do. So,
You're going to do great. I know
um,
it.
thank you. I hope so. But yeah, that's a little about me.
I'm wondering if each of you could speak to, and I know two of you, were coming from class, so didn't see Professor Colleen's full class, but wondering if you could give our prospective students here a sense of kind of what they just saw, what they can expect from first year classes, and how they should be approaching those. Anybody who wants to jump in and take that or add on.
So Professor Coleman gave you guys a really good example and sort of a bite-sized version of what a class is like. Torts in particular, it's all about cases, it's about rules. Cold calling is a thing. It's one of those things that you worry about until you do it a couple of times, and then it's no big deal. Um, I remember first year, first semester, our first class was Torts 1. Um, our classmate Abigail was the first person in our group who got cold called, and we were both terrified and impressed with her performance. And last night, the three of us are all sitting in a couple of classes where everybody's getting cold called, and after 4 years, it's no big deal. It's just part of how the process works. But it's a discussion, it's an exchange of ideas. And so that what you saw in that demonstration is really how it is, and it becomes very comfortable.
Justice or Eli, any perspective?
If I, yeah, could add to that, like we mentioned before, and if you will be in the evening division, you'll probably have the same experience, but we all took the same classes, for the most part. And throughout my experience, I think our class especially has been really collaborative. So you hear all the stories about how competitive it can be. Um, and even here, I've heard stories about the day division and how they're competing with one another. But at least for us, what I've felt is that you can ask anybody anything, which I think is a great thing. Like everybody wants you to succeed, professors and your fellow classmates. So I'd say that's something great, about the evening division and what we do, and among other things, but that's one of my favorites.
Right. And I agree with Justice and Michael. I think the culture at Delaware Law School is very hands-on. I feel like like for example, if I'm not sure if she'll be teaching, but Professor Turzin, who also teaches torts, yeah, no, we'll get a reaction from Michael and Justice. There's a lot of she teaches by acting very often. Why she has props. It's very fun, frankly. But if I were to go back to where you guys are, I'm assuming you're all looking at law schools and whatnot. I want to know two things. One is the cold calling experience, which you guys I'm assuming, just had. I joined a little late. And secondly, is that grading in law school. With long story short, you have a final and a midterm. Those are your grades, and it's definitely a big adjustment from undergrad. And I think for me, the pressure is definitely one thing that's tough to harness, and that's wherever you go to law school. But to what Justice and Michael were kind of saying, the environment in Delaware law is really is positive. I would say. I think again, Justice and I are great friends. I'd say Michael and I are good friends as well, and that's pretty much for everyone in our whole class. We're very, I would say, pretty tightly knit unit, and it's again, law school is going to be hard no matter where you go, no matter where you try to do, whatever you do, litigation or transactional law. But I think the most important thing is that you're comfortable where you're at, and that's my best advice moving forward for you guys.
I think that's such good advice and segues into the next question I wanted to ask you all about. Why did you choose Delaware Law School? Maybe even what's your favorite part about Delaware Law School to give our prospective students. And again, we have people here who are not sure if they want to do full-time, part-time. Certainly, we're trying to highlight our part-time evening program because you guys are amazing. But, why is it that you chose to come here?
So for me, Delaware law is really about accessibility. I'm a working professional, have been for a long time, so I couldn't give up my job, and I needed something that would sort of accommodate those needs. That's what got me in the door. What really encouraged me to stay was, professors like Eli mentioned, these great professors like Professor T and Professor Crystal and some of these other folks that we had in that first year who were teaching great classes and presenting great material, but who were also available for, a quick Zoom call with a question at 2 o'clock in the afternoon on a Saturday, which is the only time that I have to study, or who can make some office hours where none existed before to accommodate the needs of the students in these classes. And this kind of thing, being able to access, people who are really great legal minds and who have been presenting this material at a high level for a very long time, and a field that has a reputation of not being accessible. That's not the case at Delaware Law. So I'm getting my education in the classroom, and I'm getting all this other extra support because, as Justice and Eli mentioned, the whole organization moves as a unit towards, the success of the student. I really felt that. I really benefited from that, and that helped get me here and keep me here.
I guess we'll just stick with our usual order here, but I would have to say kind of the same thing. Widener was pretty close. I was living in Westchester at the time, which I don't know where y'all are from, but Westchester is very close to to Delaware, and it was an easy commute. Um, I was able to get a good scholarship and financing, so that was definitely a factor that helped me decide to get here. And then kind of like what Michael said, when I got here, it did seem like the professors made it interesting. I think, if I'm being honest, there's definitely going to be some that are going to part were helpful. They'd make time for you, and yeah,
Eli, did you want to jump in? I might have just lost my audio. I apologize.
Yeah, no, same here. I was trying to figure it out if it was on my end or whatever. Yeah, but I think so. When my first year at Delaware Law, I actually worked 7 days a week. I worked 5 days a week as an English teacher, and then I worked on the weekend as a bouncer at clubs. And now I'm going to be an associate at a very small law firm. And I actually started working there as a law clerk at my third year. And I guess, long story short, I really found my way as I progressed through law school. I really like contracts. Our contract professor, Professor Regan, excuse me, he's great. He really honestly sparked my interest in contracts, and that kind of steered my career in that direction. And now that's what I'll be doing professionally. I think also too, and again, another thing I learned that I really wasn't aware of before law school is that there's litigation and then there's transactional law. And I think a good part of one of the Delaware law's bright sides is that there's a lot of transactional law going on here. I mean, not for nothing, it's Delaware Law School. Delaware is the central for incorporating businesses. So therefore, there's a lot of connections in that field if you're interested into it. Like I said, going into law school, I was an English teacher. Going out of law school, I'm working in the business sector. So I think it kind of speaks for itself. And, kind of what Michael and Justice said, it's really just fun hands-on experience. Like Professor Reagan has some great hypotheticals. And it's just, again, it was enjoyable to come to class. And that's after working 8 hours a day and having to commute. And for me, my commute is around 40 minutes. But frankly, it's not that bad. It's totally manageable. And it's funny. I was talking to someone else in our class, and I was saying if I had to go back and do this all over again, would I go full time or part time? I would probably stay part time because I think being able to work and being able to kind of find your way as you go was not only fun, but it kind of made me appreciate my classes more and really try to focus more and get more out of them. So there's that.
I love that. And I hope you're all seeing kind of a theme where you saw it with Professor Colhane, you're kind of seeing it through these students, our students here, is that our faculty are here to make this experience a transformative one, even an enjoyable one, even in the hard moments. So, I'm always pleased when I hear students talk about it. That was my experience when I was a student here many years ago, and it's great to hear that that continues to be, what we're about here. So I have other questions kind of queued up to take us through, but I want to give an opportunity to the prospective students in the room to, if you just want to unmute and ask our students your questions, or you want to put them in the chat and I can field them. I want to make sure that we have kind of these last 10 minutes or so for you all, because this is your chance to ask these students anything you want. And again, remember, they're evening division students, but a lot of their advice and perspective, I think, will translate to even if you're thinking of the full-time program. So feel free to fire away.
Professor, if I have a general question for the current students. I am an all but dissertation from Widener. I would definitively be in the night division. I have a similar situation as the men who are her students working. So to not work, it's not an option. I had a very good experience at Widener. And then that's a whole other thing. I think my question is, I'm hearing similarities. I'm used to the hard work. I'm used to working 6 and 7 days a week. My question is my chances of getting admitted. Yes, I'm an educated person with 2 masters and all but dissertation. And as a widow now, this is something that I am considering. The LSATs. Tell me about that process and how did it weigh into you getting admitted, I guess, and how did you prepare for the LSATs? I think that's kind of, and I'm not even going to put the cart before the horse in terms of the bar exam, but
Yeah.
I think my general question is about the LSATs and what importance is placed on those and what the students did to prepare for that.
Thanks, Rebecca. Let me start, and then I will absolutely let the students maybe talk about their approach to the LSAT, just because they've taken it nearer in time. But what I can tell you about the admissions process, first is I hope if you can join us in person, you will join us in person on January 25th. We'll have a lot of programming around the application process, but to your question, we take a holistic approach to application review. So, certainly your academic record and your LSAT score, those are two concrete academic indicators that we can look at that tell us something about your ability to succeed in law school. And your ability to succeed in law school is directly connected to your ability to pass the bar. So you can get a great job, like it sounds like our students have lined up, which is great. So yeah, it's a holistic approach though. So it's not just here are your numbers, here is the answer it spits out. We are going to look, and dig beyond that. We're going to look at, if you have a graduate degree, or multiple, if you have, work and life experience, and what does that look like, and what are the skills that we can see that you have that are transferable to law school. Certainly I always tell students to just to get a sense of us in every school, go to our website, check out our class profile for the most recent incoming class. We even break it down by part-time and full-time, although they are the same criteria. And that way you get a sense of what our LSAT and what our GPA medians are. And that is not the beginning and the end of the story, right? That just gives you a sense of what our accepted students from last year looked like in a statistical sense. So I would say it's a factor we can't ignore because it is a data point that tells us something important. But I wouldn't say that should be your only focus. You want to take the opportunity in all the application to tell us who you are, because these students that are here on this call, I don't recall their applications at the moment, but I can tell you that, it was, likely all the other things that they have clearly brought to this class, their unique perspectives, background, voices. And so those things are what we're looking for. So that's just a little more about the admissions side, but, certainly if our students want to speak to or can speak to, what was your approach to the LSAT? If you have any tips or advice, maybe that would be helpful to Rebecca and to our whole group.
Yeah, so let me
Thank
tell on
you.
myself. I'll share some info that maybe my comrades here don't even know because I think it might be. So I sat in one of these sessions in January of 21 when I was thinking about coming to school and had a lot of those same questions and not the courage to ask. So it might be helpful to sort of share my experience in that. So I came to Widener with an undergrad degree and an unimpressive GPA. It was less than a three. Was my cumulative undergrad GPA. It was not great. It was a degree that took me 15 years to get. Um, After high school, I dropped out of undergrad when I first went to college. I was in the military for a while, worked for a while, came back to college, didn't do great. I'd like to joke that I was out of post-secondary education for so long that when I came back to get my bachelor's and took a science class, they'd added a whole nother state of matter. When I was in class, it was solids, liquids, and gases. When I went back to college, it was solid, liquid, gas, and plasma. So a whole new state of matter. So it didn't do phenomenal. It was respectable, but I'm not the straight A student that everybody thinks gets is the only ones going to law school. I didn't, and I'm not recommending that you do this. It's just what I did. I didn't prepare for the LSAT at all. Someone told me that it's an aptitude test. They said you either have an aptitude or you don't. And I went and took the test, and I ended up with a reasonable score. It was slightly higher than what the median was for the incoming class of Widener that year. So I put a package together and applied. And I wrote a very honest personal statement talking about my life experiences and what I had learned throughout my professional life and through my academic life and all this kind of stuff. And for whatever reason, they decided to let me in. I've done very well here. My GPA is a lot better than it was in undergrad and law school. And the reason that that happened is one, we have great faculty and I have great classmates who I can work with in a collaborative environment. My life experience taught me how to work. It taught me how to do this work. It taught me how to manage my time. It taught me how to handle this pressure and do these things and succeed. So, if there's a blemish, what I would encourage you to think about is if there's some blemish or something in your academic history or something like that that you're worrying about, uh, this isn't a place for spotless students and folks who come ready to obtain a degree. It's a place for people who know how to work and are ready to learn. And if you can do those two things, I would tell you that I think that you would do very well here.
And Rebecca, just one thing too about the
Thank you.
LSAT, and I think my God was great. Thank you. Um, God forbid you don't do great on it, you can always retake it. And that's what the bar, and those are these big tests. And I took the LSAT twice, just to put in perspective. I took it during COVID actually, so it was all online, and that was rough. But anyway, long story short, I think a big skill of law school, and I know we're running out of time, but I'll make it short. One of the biggest skills of law school is managing stress, and I think it definitely tests you pressure wise. I think we're all going to test that here. But the LSAT, if you don't do well, you know, take a class for it, see what, really focus and figure out what you need to learn, do better, and take it again. You will get where you need to go. It sounds like you'll be in a good spot as everyone else here. But with the LSAT, don't do well, do it again and figure it out until you get there. But yeah, that's all I got.
No, those are good. That's great advice,
Thank
and
you.
yeah, really great, honest feedback, which I love. Wonder if anybody else. Again, I know we're coming up against time, and I want to be respectful of everyone's time. But does anyone have other questions? I'm happy to stay here for a few extra minutes if our students are. So please take this opportunity to ask them what you want. As you can tell, they're again all of our greatest students, but they're also really honest and forthright and willing to help. So please take this opportunity if you'd like.
I'm wondering how you found managing a full-time job with starting school, especially if you'd been out of school for a little while.
So for me, it was a very disciplined approach. It sounds really extreme. My first year, I made a calendar of my week and accounted for every hour of every day. And it was so much so that I accounted for this is when I'm going to be asleep. This is when I'm going to wake up. This is my work time. This is my in-class time. These are my commutes. I used a sort of math problem. where I sort of figured that for every credit hour I was taking, I'd need to study for 2 hours outside of class. And so I built that into my week. It ended up being, I was working 40 hours a week and doing about 36 hours of school stuff, whether that was in class or studying at home. And I mapped out my week and I said, this is what I'm doing at this time. If you're really deliberate and you're really disciplined, it's manageable. It's definitely manageable, and it becomes very routine after a time. But for me, it had to be a regimented approach. I had to have a plan.
And I'll just say Michael's done great. He's one of the smartest people that I know. Well, first of all, can you hear me? Because I think last time I talked, I cut out.
We got you. Yeah, we got you.
All right, cool. For me, it definitely wasn't as regimented, but I've heard, like, even when we started in orientation, I remember hearing one of the 4L evening division students say exactly what Michael just said, and they map out every hour when they sleep. Um, for me, I just don't have the capacity to do that. So I just kind of found time like to get crafty, I guess I want to say. So like if I'm studying on the way to school, sometimes I recorded myself and listened to like a lecture in the car on the way, or like um I didn't do this that often, but like had post-it notes in my car so I could just review it if I needed to like know a couple elements like you will and when you take torts or other classes. So it's just for me, I think it was a matter of just finding the time and also making sure that I didn't overwork myself and wasn't constantly run down. Just get kind of crafty with it.
Yeah, and I think it's important to find what works for you and also find find the support and resources that we have for you here. So again, I want to be respectful of everyone's time, but I think I'm okay to say that these students are could be resources for you, would be resources for you, as would really all of our students. I have never ever spoken to one of our students who has told me they weren't willing to help or weren't accessible and available. So certainly reach out to us in admissions. We can certainly connect you to somebody so that you do have a person you can ask these questions to. But again, I want to really take a second to just thank Michael, Justice, and Eli so much for taking time because they are so busy, right? Full-time professionals, full-time student, or part-time students, but that's a full-time job in its own right. So I really appreciate you being here with us tonight in this kind of intimate setting, so that we could get your perspectives. Again, I know we could probably go on for a long time, but I want to stop it here and hope that if you do have more questions, you'll reach out, and that if you can join us in person, I really highly suggest you join us on January 25th. It's a Saturday. It'll feature another mock class by the dean of the law school, which will be really fun. We will have presentations on admissions. On how to write a personal statement, an effective personal statement. There'll be campus tours, more students, other students to talk to. So please consider coming to campus and joining us. But again, want to wish you all a good night and thank you so much for coming here tonight.
No problem. Thanks for having us and good
Yeah,
luck.
exactly. Thank you for having us. Yep, and best of luck, guys, in your application process, wherever you end up. It's
Yes.
a
Good
fun
luck to you. Can't wait to
process.
see you on campus.